So good morning, guys. This is part six of lesson six of part one and unit two. Unit two has got three chapters, so we are in the second chapter. We have already completed up to RBI guidelines and regulations for MSME sector. Today we'll cover types of customers and legal provisions related to them. So this is the sixth chapter we have, and let me just take you through that. So this is there type of customers and legal provisions, and there are six topics in this chapter, right? So again, important part, and it is unit 2, right? So let us start with topic 1 without wasting our time. So, when it comes to borrowing request that you need to assess, you need to understand each legal form of business. That is very important because everything will change according to the business, the type of business. Like for example, for there will be different documentation procedures for proprietorship, partnership, private limited company, public limited company, and all. So, your organization may have different policies and procedures for extending credit to the different types of organizational structures, and different will guidelines will also be provided for different type of borrowers. Now, this lesson discusses some of the basic forms and legal structure of business organizations. Although the list provided here is a short and generic, most lenders have policies regarding extending credit to different legal form of business. These policies provide specific guidance for the lender and protection for the organization. When reviewing the lesson, keep in mind that you must consult your own institution's policies and procedures for specific guidelines. So, by the end of the lesson, you should be able to describe the various customer types and their key features, describe the applicability of various acts, assess proposals involving partnership firms and limited companies. So, these are the things which are important. Let us move to topic 2. So the topic 2, this is always very important. Topic 2 always remains very important, as we all know, right? So we'll just make it bigger. So what you need to do know is, first of all, just let me make my pen. Yeah. The customer segments in any business comprise of individual, proprietorships, partnerships, companies, and so on. They are each distinguished by their individual constitution. Normally, individuals carry on businesses that are very basic in the nature and do not require high capital investments. So it all depends on the capital, the investments, the kind of structure you want in your business. Like what is the customer type, like individual, proprietorship, partnership, and companies. There are various legal forms of businesses in India. Each has its own benefits and drawbacks as well as legal ramifications. You should also know that the way an entity formed is based on the types and volume of business. So it also depends on the type and volume of the business, like what kind of form of business a particular entity is selecting. Now, this lesson discusses two distinct types of legal entities. So there are two distinct types of legal entities. One is individual and proprietorships, and second one is partnerships and companies. So individuals, any person who is of the age of majority means more than 18 years, is eligible to enter into a valid contract. An individual can do a business in their own name or as a proprietorship. Examples include chartered accountants, medical professionals, and legal practitioners. So, an individual, a proprietorship is an individual based legal entity, individual based business entity. Now, let us come to proprietorship concern. Many SMEs are run by the individual on the sole proprietary or proprietary basis. You know that, meaning they do a business under a firm name. So they have different firm. Like if I, for example, Dr. Abhishek Tripathi, want to start my own business of financial consultancy, then I may name it as MS. Maybe because my mom name is Vidya, so I may name it as MS Vidya Enterprises, right? So it may have different name, but there's sole one person who is the owner. So that is proprietorship concern. Individuals and proprietorship. So individuals carry out all the type of activities such as procuring raw material, finished goods, marketing, and servicing. For example, carpenters, plumbers, doctors, legal advisors, and chartered accountants all provide services on an individual basis. Some individuals carry out their business under the name of proprietorship. For example, MS Thomas and Sons. with a view to distinguish their personal income from their business income. In this case, the volume of the business is much larger than that of an individual business. Now, for a sole proprietor, there is no difference between the individual and the business from the taxation or regulatory perspective. So, there is no separate legal entity. In case of proprietorship, there is no separate legal entity. It is one and the same. The owner and the business is the same. So if you are a plumber named Raju Sharma and you start a proprietor plumbing service firm called Raju Sharma Enterprises, the government does not difference between Raju Sharma Enterprises and the individual. The Raju Sharma and the Raju Sharma Enterprises are same. Now another business formation you may occasionally encounter is called as Hindu undivided family business formation. There are unique elements in the form of business. So Hindu undivided family, so, what is how Hindu undivided family is formed? Joint Hindu family is not created by an agreement or any contract in this business form. Is a function of Hindu law. So, it is governed by Hindu law. It is not governed by Companies Act. It is not governed by Partnership Act. It is governed by Hindu law. Registration is not required. Membership. Two types of members are there. One is Karta and another one is co-partners. Karta is the eldest member of the family. So he's the kind of manager. He's the eldest member of the family who controls and normally manages its business. The other members of the family are called as co-partners. So they are beneficiaries, right? But on behalf of all co-partners, Karta manages the business. There is no limit on the number of co-partners. So there can be n number of co-partners. Now, responsibility. The head of the family or the Karta has full responsibility of the management of joint Hindu family business. He is free to make any decision without interference of any co-partners. However, he can take advice and help of the co-partners as desired. So he can take advice, but he's free to take the decision on behalf of the business, right? Then liability. So the liability of the Karta is unlimited. However, the liability of the co-partners are limited up to their share in the business. So, the liability of Karta is unlimited, but the liability of co-partners are not limited and they are limited up to the shares in the business. Now, sharing of profits or losses. All members have equal rights to share the profits as well as losses. So, all Karta and co-partners have equal rights to share the profit. Now, rights of Karta. Karta can make contracts, draw bills, etc., but not wind up debt or debts already due to the joint Hindu family. So, he can make contract, he can draw bills on behalf of Hindu undivided family, but he cannot wind up debt. He cannot close debts, right, which is already due on Hindu undivided family. He has the authority to sell and create a mortgage of the property of HUF while conducting the business. So he can sell or create a mortgage. So he can mortgage the property also on behalf of Hindu undivided family. So this is about HUF, right? Now let us go to partnership and companies. So with the growth of the volume of the business, two more individuals are likely to join business. Two or more individuals are likely to join together and conduct business as they will have the benefit of sharing investment expertise and market access as well as the risk. These are called as partnership firms which operate as a set of specific guidelines. Much bigger business, which involves a substantial amount of investment and infrastructure, are run by forming a company. So, if proprietorship is most basic, then so after proprietorship, if we talk about proprietorship is the smallest one, then partnership, then we have company, right? So So when a group of people own a business, it is either a partnership or a company. So a group of people cannot have proprietorship form. Proprietorship form means only one owner. Now, if a group of people want to operate a business, they will have to either make a partnership form or make a company. With the comprehensive information about these business formations included in PDF document. So these things are included in PDF document. Let us just go through these things as well. So partnership and companies. There are various laws, act that apply to the loan processing. Partnership Act of 1932, a Limited Liability Partnership, LLP Act of 2008, and Companies Act of 2013 and 15. As a lender, you need to know that each type of business entity requires specific underwriting and lending treatment. Any deviation from the policy procedure may have legal ramifications. Let's look at a few of these in general terms that you need to be aware of. So it's very important that you need to understand that each business type has requires a specific underwriting and lending treatment, right? Specific assessment techniques are required for each type of business. Now, laws and acts of partnership. Verify the partnership deed. Very important to ascertain who are the partners and their rights in the agreement. So, very important whenever any partnership firm comes to you, need to first of all verify the partnership deed. The second one is determine whether there is any minor partner, as they assume no liabilities but are entitled to benefits. So minors are partners by benefits only, right? So again, very important that you need to verify that the minors are like if there is any minor, then you need to verify whether there is any minor which is included in the partnership. What will happen in case of minor? Minor is like whenever there is benefit, they are part, but whenever there is loss, they are not. So determine who and how the partnership is allowed to borrow funds. So very important, the borrowing clause you have to check from whom, according to partnership deed, from whom they are allowed to get money, and who is allowed to get the money, who is authorized to sign on behalf of this. Now understand the effect of the partnership's retirement, resignation, death, etc. on the continuation of partnership business. So very important, you need to read the partnership deed very carefully. You need to find out what is the effect of partnership's retirement, resignation, death, right, on continuation of partnership business. Now, laws and acts of partnership. So, verify via MOA, Memorandum of Association, whether the company's borrowing needs align with the objective for which the company has been formed. So, if they are borrowing according to the like their objective clause, like for example, if a company is borrowing for their own business, then it is okay. They cannot borrow it for director's daughter marriage, right? So, it is not in their objective. Now, the borrowing powers are exercised by the board of directors. The borrowing must within the limits set in the MOA and article of association. So, it is exercised by board of directors. So, directors exercise on behalf of the company the borrowing power, right? And next thing is it is as per the limits of the borrowing are specified in MOA and AOA, Memorandum of Association and Articles of Association. Now look for board resolution. Also, how board will allow, for taking loan. It is through board resolution. So you have to look for board resolution permitting accounts to be opened with a specific bank and avail financing. Now, assets charged for the company's borrowing needs are to be registered with the ROC within a specified time limits within 360 days from the date of the finance. So, whatever assets are there charged in the form of security, it is to be registered with ROC. ROC is the registrar of companies, right, within 360 days. Now, non-compliance in this regard result in loan becoming unsecured. So, if you don't register as a credit manager, if you don't register the charges with ROC within 360 days, then your whole loan will become unsecured, which is again not safe. So there is distinction between one person company, private company, and limited companies. The following table will help us to understand the major distinctions, right? And you can download this table and you can understand what it is. The basic difference is one person company is like new introduced version of a company in Companies Act 2013, where even a one person can form a company, right? Private limited companies where limited number of members are there, limited number of shareholders are there, and public limited company is a company where are unlimited number of shareholders are there, right? So this is the difference between one person company, private limited company, and public limited company. Also, one person company and private limited company don't have their shares issued to the public, but public limited company will have their shares issued to the public, right? So public ownership will also be there. So these are there. Also there are various things like there is no provision of certificate of commencement of business in case of one person company and private limited company, but in case of public limited company, certificate of commencement of business is issued, right? So this is also one of them. So go through this. If you have any doubt, just ask me, right? So this is end of topic 2. Let us go to topic 3. So to assess the credit risk of your client and structure or a loan for approval, the credit professionals should understand the basic business model. So first of all, you have to understand the basic business model as well as the legal structure of the borrowing entity. To address this issue effectively, you should identify the borrower's legal structure and collect and review necessary documentation. So you should collect documentation on the basis of the legal structure of the borrower, and you should actually analyze that. You have to read it very thoroughly. If you are lending into partnership form, then you should ask for partnership deed. If you're lending to companies, then you should ask for memorandum of association and articles of association and certificate of incorporation, etc. Then assess the credit policy implications and degree of financial risk associated with the current or proposed legal structure. So you have to assess, you have to keep in your mind what is the financial risk related to a particular legal structure of the business, right? And you have to assess the credit policy implications. Now think ahead to the loan structure that may be involved with a given credit approval, and make sure you will be able to mitigate risk with credit enhancements that make the legal structure. So always whenever you try to whenever you find the probable risk, then try to mitigate the risk, try to find out measures how you can mitigate the risk. Now assess whether there is need to consult with an empaneled legal advisor of the bank. So always try to consult. If you don't know about the legal ramifications, try to consult with the empaneled legal advisor of the bank. Every bank has legal advisors, you can consult them. In case of proposals related to the company, determine whether there is any clause in MOA and AOA. So there has to be a clause in the MOA or AOA that prevents the bank from financing as per bank's credit policy. So you have to identify in their MOA and AOA whether there is borrowing clause or not. If there is no borrowing clause means whether the company is authorized to borrow or not, right? And if they are not, then you cannot lend them. And determine via the MOA who the promoters, owners, directors are, and whether their background are in line with the activities of the business. So promoters, directors, and owners are also very important. You have to check their background. You have to find out whether they belong to the same business. Otherwise, tomorrow, they will leave the business and they will fly away. Now, verify the powers of the authorized persons with regard to the execution of the loan documents and extent of borrowings. So, you have to verify the powers of the authorized persons, right? Whether who's authorized to execute the loan document, who is authorized to borrow from the bank on behalf of the client. Now, determine whether you have other sources to independently verify the authenticity of the company documents. So, verify the authenticity of company documents from various sources. You can go to ROC, you can verify, you can check a PAN card of the company through the income tax authorities. Online it is available. Income tax, PAN card verification, GST verification, all those things should be done. So this is topic 3. I think this is good. Now let us go for topic 4. Now this is a case study, as we already always have. So now, MS Srinath and Company, a partnership, approaches you for a credit facility of 20 lakhs to purchase machinery worth 25 lakhs. So 5 lakhs they are contributing on their own, and they are asking for credit facility of 20 lakhs. They are prepared to contribute a margin of rupees 5 lakhs. There are 4 partners. So there are 4 partners: Mr. Srinath, Mr. Murali, Mr. Krishna, and Master Giridhar. Master means you have to check whether this is minor or major, because it is minor, it seems. Now, their shares of the partnership are 40%, 30%, 20%, and 10% respectively. They are seeking your guidance on the following: document needed for the loan request, personal liability, who is needed to execute the document as one of the partners presently out of town, whether they can authorize one of the partners to sign. You have learned that in order to proceed with the loan request, they must submit their partnership deed, certificate of registration. So these are the things, documents required for the certificate of registration and KYC document of each of the partners. In case the partners are jointly and severally liable, however, the minor partner, Master Girdhar, is not liable for the loan but is entitled to the benefits of the unit because he is minor. You tell them that yes, all the partners should sign the document by visiting the branch. Additionally, a guardian will sign on behalf of the minor. So for minor, a guardian will sign that he will be he is subject to this particular loan, because he cannot sign, he cannot contract. You can also let them know that yes, they can authorize one of the partners to operate the account by giving an authorization letter signed by the partners. So they can authorize one of the partners by giving authorization letter to operate the account. Right. So this is the case study. Now topic 5. So now they that you understand the various types of SME customers, their key features, and the applicability of the relevant tax in order to structure an SME loan appropriately, as well as safeguard the interest of your bank, you should ask the following question: does your bank policy prohibit or inhibit any way lending to the business with certain legal structures? Are there special requirements in terms of documentation or information based on the nature of the business structure? And is the borrower's legal structure appropriately documented so there is no doubt as to the structure, ownership, liability, or legal requirements? Right? So these are the things which you have to ask yourself. And last one is last topic is, as always, it is the questions, right? So you can check your knowledge, you can solve the question, and I hope this you enjoyed this particular lesson. Thank you.